All right, this one is going to be pretty technical. Basically, what's going on is there is a rewrite of the city code, Title 5 and 6, and this has to deal with rezoning. So this hearing is happening this Tuesday, which is December 12th, 2023. The public hearing has been closed, so I'm just letting you know what's going on. Maybe, depending on how the Planning and Zoning Committee decide to vote on it, um, they'll recommend it possibly to the city council, maybe motion to direct staff to make requested amendments to table it to a certain date, or also to recommend a denial to the city council. Now, what exactly is um, in this document? When we say it's a rewrite, now this has been going on since probably it looks like to be, I mean, I think from like April of this year. So 6 months, more than 6 months, this process has been going on. Who pushed it? Where is the origination of all this? I don't really know. I don't know if it matters at this point. But really, the thing that probably surprised me the most, because I'm going through past hearings regarding various topics, and the thing that surprised me by looking at the exhibits, because I was like, okay, well, what exactly are the changes that they're wanting to do? And I was surprised to see the red line version. It's 289 pages. That's the kind of that's how long it is. And I'm like, what? They're just gonna vote with one vote, yes or no. I mean, this. I guess maybe this is similar to U.S. Congress, passing the omnibus bills, right? Which are just, there's no way they could have read through it all. I believe even like the packets are provided to them like the Friday before the Tuesday hearing or something like that. So, how can you go through that? Now, for my business, what I deal with a lot of these sorts of agreements, lease agreements, purchase and sale agreements, dealing with the commercial real estate world, hotels. I think I've seen as long as like 67 pages, legal documents. I think, it's Times New Roman. What is this font? I'm not sure what font this is. That's a little bit too nerdy, but Times New Roman, 67 pages, maybe simple leases can be like 30 pages, but 289 pages. You really have to be an attorney to go through all of these changes and see and understand what the ramifications are. Now, I thank God that they have these red line versions, so you can see exactly what sorts of changes that they're planning on doing. Now, I'm not necessarily saying anything of particular action because I've come so late in this deal. They did have like a workshop back in like April of 2023. So there's been plenty of times that the public has been had an opportunity to talk about this. Whether it gets reopened again before the city council, before they vote on it based off of the recommendations of the Planning and Zoning Commission, I don't know. So I'm just going to point out some things that I thought were interesting in terms of what changes are. And, even different versions, what you'll see is if you look at the agenda, you can see the agenda packet downloaded from the Kuna website for the Planning and Zoning Commission. You can see here that there are actually that there were multiple versions. Oh no, that's here it is. Part of their exhibit list. You can see that there were multiple versions of the rewrites, and this is based off of different feedback of the council members. Now, one of the problems I have with this scale of changes, 289 pages, almost 300 pages basically, is that when it comes to public comment, they only have 3 minutes. So how are you going to address these issues? And then also when you're a public 4 or 5 member public committee council members or the planning and zoning commission, deliberating a certain topic, I'm not sure if you're actually going through each item, line by line. Usually when I work with my attorneys, and we're looking at, red line versions between us and the opposing council, we're with the tenant, I'm from the landlord perspective, we're going line by line items, and sometimes we're even meeting, with the other attorney, and we're literally going line by line. Most changes are pretty non-consequential, just kind of like cleaning up language, but other times they matter. So sometimes I say to my attorney, if I'm not particularly interested in diving deep, I say, okay, what are the red flag issues? What are the main issues that we need to review? So anyway, but you can see here that they have multiple versions, and I'm not, what you see with legal contracts when it keeps going back and forth with different draft versions between attorneys is you'll see all of the different versions on the same document, and then Microsoft Word has this thing where you can see the different colors like blue, green, red, and you can see how it's changed over the time. In this case, we don't have that. There has been different commentary from different individuals on the various changes, but they might be referring to different drafts. So in this latest draft here, let's just go through it really quick here to see what popped up. One thing that's interesting is they are adding a food truck court definition, a property used or developed to accommodate one or more food trucks as a primary use of the property while possibly accommodating areas on the property for entertainment or recreational opportunities. Food truck courts must have a valid certificate of occupancy in addition to all other applicable permits and inspections. I guess they didn't have a category for that. They added here lot split public utility, dividing of a lot, tract or parcel of land for the purposes of creating a public utility lot. And maybe we'll take a look at what that looks like. A lot of these things are just capitalizing the term title when you're dealing with specific things, terms. Sometimes you want to do that. Let's see here. Here's that public utility lot thing again. And the tough thing with this vertical screen is I can't. It's hard for me to read it. I prefer horizontal, but I think most people seem to prefer the vertical now because everyone's watching on the phone. Ali. Now, I may be missing things that are important, and frequently, sometimes I do miss things even when I'm reviewing commercial documents. Okay, so here is something that is interesting. There was a comment that was made that, and which is understandable. Frequently, the Planning and Zoning Commission, right, which are assigned the committee members of the commission, the members of the commission are usually appointed by the elected city council members, and typically the Planning and Zoning Commission don't really have any sort of power, because at least on the Ada County level, I don't really know. It just kind of gotten in the process of having them involved, but they don't really. I mean, they could recommend against a project, and then the commissioners, they'll listen to it and then just overrule them and rule how they want. Even the staff members or the county staff may recommend or not recommend a certain project, and then the commissioners can just overrule it and rule how they want. So in this case here, what you have is a table. Let me see if I can, because it went horizontal, and you can see a little bit how things have changed, perhaps a little bit. So they added this new thing called a lot split. Now that's, so here you can see the recommending body. It's none. This would be a D, which stands for director. That means this would be an administrative decision. Now, Ada County has this already where you can do an administrative lot split if the lot that you're splitting is from like before has been basically unchanged since before 1979. And it seems to be something similar to this. So I did an administrative lot split and then a boundary adjustment. I did it all in one, and I didn't have to go through the public hearing process. So this lot split idea seems to be in line with whatever Ada County already has, and I believe even Canyon County has something similar. I'm not exactly sure on that, but okay. So anyway, here so you have the recommending body. So here, typically you see here that for the actual decision-making body, the Planning and Zoning Commission really it doesn't matter. Like even they don't really have the final say. Design review, for example, I'm not too familiar with that. Special use permit, okay. I'm not too familiar with that actually either. But most of the time, you see ultimately it's the city council, which is CC, which makes the final decision. So one of the comments by one of the staff members in, I believe, one of the city council meetings was that typically or oftentimes the developers will just kind of not take the planning and zoning commission very seriously. It's like kind of a dress rehearsal, so to speak, for the real performance, which is getting the approval with the city council. But okay, anyway, so you got the lot split, which is kind of something to be aware of, to look at, and then there is time extension. So this is in reference to the fact that these time extensions keep getting brought back to the city council staff, and maybe it can just be automatically renewed because, as far as I understand, and pretty much what I think one of the comments, some of the commentary was, well, we just extend it anyway. What are the reasons that we can deny the extension, right? Because we're allocating these dwelling units, right, which relates to, I guess, sewage, traffic issues, future planning purposes, and then you have developers who aren't, can't sell their lots, can't get the financing to, build the homes on their lots, and so they just keep extending this, kind of like a zombie project, just letting it linger out, and then maybe one day when the economy comes back, when interest rates, for example, right now are just not absolute record highs, but just very high to the point where there are no real new constructions happening. They just kind of want to push the project out. And normally these projects are approved pre-plats for maybe like 2 years maximum, and so before they need to like build the roads and build the sewage lines and do whatever prerequisites to get the final plot, which means getting the actual tax parcel ID numbers, and then when they can actually sell those lots separately. So sometimes you get the developers just coming back over and over every year, requesting an extension, and you're gonna see this a lot more, especially should we start hitting the downturn. So there's 2 layers of time extension that appears to have been added. One is for the director to be able to just do it himself. And then there's another layer of time extension which requires from the council. So we'll take a look at that. There's vacation, all others, and variance. The director removed himself from that recommending body and just allowing the Planning and Zoning Commission to take that. Yeah, I mean, it all seems pretty straightforward, but once again, I could be off. There may be implications of all this, and I'm going to refer to this video. Yeah, I think it's kind of it would be unfair for me to say like, oh, we haven't had time to review it. You guys, have had it since like May, and I just haven't been making this podcast um, long enough. Um, Now I don't live in the city, so I don't have really a dog in this fight. This is just me observing and reporting. And if you see anything that particularly is of concern, then you can bring it up. I think just because those two things, I mean, okay, look at the scope of this. Okay, I mean, this video already is 15 minutes long. Okay, I think from what I understand, generally speaking, probably having a specific citizen committee created to basically do a rewrite of this code and leave it open and let them have monthly meetings and review and ask questions, not burden the Planning and Zoning Commission. But that's assuming you have ready and willing citizens. And I think maybe in a smaller town like Kuna, you don't just have like lawyers willing to go through this, or lawyers that are reviewing these things, or professional commercial developers that happen to live near Kuna. I don't even know if I would. I wouldn't want to be. I don't think I would want to be. I don't even know if I would qualify because I'm not. I'm not in this city limits. I probably would not. One of the things here that was interesting was regarding the public hearing. In order that the Planning and Zoning Committee would have more relevance, there was a provision to allow half. The council shall accept the recommendation of the commission's report unless rejected by a vote of 1/2 plus 1 of the council members. Because normally, I guess normally, it's just to give them not like to give some relevance or power to the Planning and Zoning Commission, which also at the same time lessens the amount of public hearings. But that part got amended. There was, like I said, there's been months of feedback back and forth. But let me just focus, on just those two things. And there's probably a lot more that I've missed, but I'm not going to be. This is already getting a lot. Okay, so let's look at the two things I was mentioning. It was the lot split and then the time extension. Okay. Okay, so here is a lot splits. Now you have the standard lot line adjustments, and then here is the specific area for lot splits that is within the power of, what do we say it was? The decision-making body is the director. So this is purely an administrative decision. So a lot split is a dividing of an original lot, tract, or parcel of land. A lot shall not create more than 3 new parcels from the original lot, tract, or parcel of land, including any splits granted by the county prior to annexation into the city. The burden shall be on the property owner to provide evidence that they are eligible for a lot split with the city by way of a deed and legal description of the tract, demonstrating its existence as an original lot, tract, or parcel of land, and its configuration as of the date of application for lot split. This from various commentary that I heard. This whole thing is just to allow, if you eliminate the public discussion, if you allow this to be an administrative decision, it means somebody doesn't need to hire there's just a whole lot of things for official subdivisions. You need to hire an architect, not an architect, but a land surveyor to plot out the lands. It can get quite cumbersome. I mean, I think you still have to do that. I don't know. Let's look at what the requirements are. Compliance. The owner shall comply with the following conditions. 2. The minimum lot size of all parcels created through the lot split process shall be 1 acre, except lots created through the public utility lot split process. I think we will. I don't know. I think we'll skip the utility lot process. Number 3, all parcels created via lot split shall meet lot frontage requirements established in the code. Okay, number 3, and here's number 4, sewer and water. Applicant shall extend public sewer and water to each parcel created when public sewer and water are available within 300 feet of the parcels or as determined by the city engineer. Number 5, if city sewer and water are not available within 300 feet of the parcel, the applicant shall comply with the septic tank system standards established in the code. Number 6, parcels located in the Kuna nitrate priority area shall not be split without connecting to city and water. A waiver of this subsection may be allowed when the applicant provides documentation from Central District Health. We'll just skip that. That's pretty specific. Number 7, land possessing unique features or topographical constraints. Number 8, utilities placed underground. Utilities shall be placed underground unless it is determined by the owner of the utility and or the city council that such action is not feasible or reasonable. Parcels created that are more than 1 acre in size shall be subject to this condition on a case-by-case review basis. Number 9, stormwater drainage. Any increased stormwater drainage resulting from lot split activity shall be retained on site. Parcels less than 1 acre shall provide stormwater plans and supporting calculations to the city engineer for review and approval. Parcels 1 acre and larger shall be subject to providing stormwater plans. Okay, fire hydrants, grading. Number 12, maximum number of parcels created. The maximum number of parcels that can be created from contiguous original tracts submitted under a single application is 5. If more splits than this amount are intended from original and contiguous tracts, that action shall occur through the city's subdivision process. That is the beast of the process. That's with the Planning and Zoning Commission. That's with the city council that requires all the public hearing, all of the notices, and is a big expense. That's the subdivision process. So this seeks to circumvent that process. 13, water rights. Water rights, let's just go past that. 14, dedication of right-of-way. We'll skip that. Number 15, lot split conformity. We'll skip that. Number 16, sidewalks. Sidewalks and landscaping shall be installed in accordance with the code for parcels abutting classified roadways. Where sidewalks are required, the owner shall submit engineered drawings, contractor's estimates, and submit for construction plan review. 17, driveway entrances. Each parcel created through a lot split shall have a driveway entrance connecting to a public street. Interesting. With adequate driveway distance separations is determined by the city and or ACHD. Where feasible, the driveway entrances shall be designed and constructed as shared driveways. Owners shall develop driveway agreements for shared driveways, and these agreements shall be recorded and follow the land. Shared driveway entrances shall have a minimum driveway width of 24 feet, unless ACHD requires a different width. The driveway's asphalt apron and entranceway shall extend inward a minimum of 15 feet from the parcel's property line to minimize the tracking of debris onto the roadways. Driveways shall be a maximum 150 feet in length. The driveway plans shall be reviewed and approved by the city engineer. That's interesting. I'm not seeing anything that it needs to be paved, and I don't believe Ada County has that requirement either. ACHD requirements. Prior to construction or installation of any roadway improvements, curb, gutter, a permit or license agreement must be obtained from ACHD. Okay, 19. Here's the thing that I think is similar to Ada County. Original lot, tract, or parcel of land. A lot, parcel, or tract of land is recorded on any plat or recorded on file in the office of the county recorder or any unplatted contiguous parcel of land held in one ownership and of record on or before December 7th, 1977. And of record. Okay, so that's two things. It has to be one owner. You have to be the original owner and 1977. So do you qualify for that? It appears that if you bought the land from somebody who held it before 1977, you would not qualify for this. Lot of record. A lot which is part of a subdivision recorded in the office of the county recorder, or a lot or parcel described by metes and bounds, the description of which has been so recorded. Owner, the individual firm, association, syndicate, partnership, or a corporation having any interest in the land to be subdivided. So this is interesting. Original lot. It does appear that unless you are perhaps the original owner right here, and that land was there prior to December 7th, 1977, unchanged, you cannot do a administrative split. That seems a little bit, I'm just reading it for the way it is. All right, the other one, which I'm going to try and skip, is the public utility lot split. This seems to allow for like easement. Instead of having to do an easement, you can just maybe sell some of the land for sewage lines or power lines or something like that. Perhaps, yeah. Okay, so there's that one. And what was the other one? The other one was the extensions. Okay, here's an area where they added another table, but you know, this is almost getting 30 minutes long. I mean, I'm just bringing some awareness to some of the things, so I'm going to finish this up pretty quick here. So let's see, extension. They called it time extension. All right. Okay, so here is kind of some explanation about time extensions. All phases of the planned unit development shall be completed in accordance with a timeline contained in a development agreement. Like, you don't have infinite time to build these things. You get approval for it, and you got to be done with it. Like usually it's like 2 years. Time extensions may be obtained through modifications of the development agreement. I think that's okay. Here it is: approval period, phase development, time extensions, and expirations. Okay, here it is. Okay, here's general on preliminary plat approvals. So a preliminary plat approval shall be valid for 2 years from the date of approval of findings of facts and conclusions of law by the council, unless extended as provided for herein. In the event that the preliminary plat is approved in construction phases, more than one phase, because sometimes, you know, they're not going to build it all at the same time. And here we got some. There we go. The subdivider shall have 2 years to complete and record the final plat for the preliminary plat's first phase from time the council approves its decision on the preliminary plat. When the preliminary plat includes phases, each successive phase is to be completed within 1 year of the preceding phase recording. So 2 years, we approved it, get it done, finish it. And then each phase thereafter is 1 year. Otherwise, the remaining phases of the preliminary plat shall expire. Okay, now here's the extension. Upon written request and filing by the applicant prior to the termination of the period, in accord with subsections that the director may authorize a single extension of time to obtain the city engineer's signature on the final plat for the preliminary plat's first phase not to exceed 2 years and 1 year for each successive phase. Additional time extensions up to 1 year as determined and approved by the council may be granted. So the first extension, which can be up to 2 years. So you remember, you get 2 years. You say, okay, your project got approved. Went through the public hearing process. A lot of headache. All right, all the neighbors complained about how bad it is, how the schools are full. Okay, you got it approved. Now they have 2 years to get the preliminary stuff, like the road in, whatever is preliminarily required. And then if they can't get it done, they can request an extension from the director. Director, we need more time. Okay, the director, you don't have to go before the board. The director now can sign it and say, okay, here's two more years. Okay, now they do the next phase. It's a multi-phased project. And then normally they get 1 year to do it. They're like, 1 year's not enough. Can we get another year? Okay, well, you go to the director. If you want any time more, you're going to have to go to the council. Okay, well, let's get an administrative decision, please. Okay, a preliminary plat approval that has expired shall not be granted a renewal or extension except as provided for in subsection J6. So we're going to go to J6. I don't know where J6, here it is. It is right here, J6. Applications for preliminary plat time extension. Here's what they need to do it. The director or council is under no obligation to grant a time extension. In approving or denying the request for time extension, the director or council may add additional conditions to its approval of the request for time extension. Yeah, I'm not seeing reasons that they can deny it. And this was part of the discussion for maybe another video that I did, or already, yeah, that you might be seeing in the future. That unless there's explicit reasons within the code for saying why a developer can't just extend, and request it, it's not in the code. So it is a little bit risky for the developer to request it, because maybe they'll get denied, but then they can argue, well, there is no reason to deny it, except maybe this number 7. It is not. Or number 6 is under no obligation to grant a time extension. Maybe if there was a big lawsuit, from the developer saying, look, your code doesn't have a reason why you denied it. It was arbitrary. You don't want to hear that word. So anyway, this was but a, you can see here, this was like 33 minutes. I'm trying to read through it. And, also the other thing, I didn't compare it to what the code was before. So this is just to give you an idea. Yeah, once again, it is a tough situation to be in, in terms of what exactly. I'm not saying any sort of action. I'm just bringing this before your attention. I mean, there really has been a lot of time. If you are wanting to get involved at this process and like really diving into each of these line items, I mean, you can see just how the extent here. I mean, here's entire sections that are being, written out, and understanding what the dynamics are, and it's. I don't. Yeah, it's just it's so much. So usually part of my discussion with my attorney, because we're seeing the changes from opposing side counsel or whatever, we're trying to do it on my counsel. What I actually do is when we have a bunch of changes, like I will actually write an email to the opposing side, and I explain, okay, this is why we changed it to be this word, this section, and this section. Because I knew that there were going to be some questions. So if they understood the intent, then it'll be easier for them to kind of explain, okay, this is why we're doing things. And from just like the public hearings, and I think maybe that's when you need kind of like these. I don't know if it would be a special committee, and I'm not trying to criticize. I'm just saying. The thing is, I don't even know if there's anybody who would be able to do it. I mean, it's almost as though you would have this, like, how great would it be, right, with all of these changes? Okay, so because you can put with every change, you can put comments, right? So if every single comment, every single major change, you had a comment, and maybe it was approved by the citizen committee, okay, explaining, okay, this is the explanation we received from. I'm not sure if the city attorney would be involved with that, but or with the director, right? And kind of the justifications or the reasons why these things are being done. And so once you have every single line item, right, with all of the justifications for all of these changes, and man, it really has been vetted, line by line, and we know the justification, and we know this is the intent for why we do it, why we changed it the way it is. And one of the benefits of that is because when things go wrong, okay, when the laws do not act in the way that the whatever citizen committee expected it to, right, based off of the explanations, when the reality of the law is different than the intent, then it becomes very easy, or it becomes much easier for city council to come in later, or for public comment to come back and be like, look, this was the intent. This was clearly an intent. We have it written in public records. Here are the comments. This was our public intent. And it turned out badly here. Can we change things, right? And you do want it in public record, and you want it in public record, because we're all going to forget about this. We're all going to forget the discussions on this. And we're not going to be diving, like, even for me, we're not going to be diving back through all of the past hearings, right? Oh, there was a public comment somewhere here on this meeting, and then this meeting somebody said that, because then you got to go, if you open up that YouTube video or you find the audio file and you're like, oh no, that's what we said, versus you just have it in one big document with comments about the intent. Now, that's just one idea. Anyway, it's like, I guess I'm just informing you what's going on. I feel bad. I feel a little bad because this is a huge project, and I can see the benefits of. I'm not seeing any. Well, maybe you can. Maybe you're going to see it if you're going to be reviewing this. But this is just a lot of information, and if there is somebody who has gone through each of these line items and you are seeing like a major red flag, feel free, to post about this. If it's something that is, urgent enough where you need people basically to go into the city council meetings. I mean, I'm going to be watching this. We'll see on Tuesday if this goes to the Planning and Zoning Commission or how they vote, and then make your decision known off of that. Anyway, I think that's about it. Have a good one. Bye-bye.